Hi there, and welcome back to Rent Prep for Landlords. I'm Andrew Schultz, Community Manager here at Rent Prep. I'm also a licensed real estate broker here in the state of New York with over 15 years of experience in the property management and rental property industries. On today's episode, we're going to be talking about tenant screening. This is actually a follow-up video to our last video on tenant screening, and in this one, we're going to be filling you in on some of the more recent changes to the tenant screening laws from around the country. We've got a lot to cover today, so let's get to it. Before we jump into today's episode, I want to take an opportunity to remind you that this is not legal advice and I'm not an attorney. You really need to speak with your local attorney that specializes in landlord-tenant law before you establish or make any changes to your tenant screening criteria. Keep in mind that laws change all the time, and we're seeing a lot of states, and in some instances, even some cities, enacting new landlord-tenant laws on a regular basis. So it's a very good idea to stay current with what's going on and what's relevant in your area. All that being said, we're going to start things off with our home state here in New York. We can no longer look at eviction data as of the 2019 HSTPA legislation that was passed here in New York. HSTPA is the Housing Stability and Tenant Protection Act, and that is the new law of the land here in New York since 2019. We used to be able to go online to eCourts and check for old or current eviction cases. Then the data was trimmed back so that you could only see the most recent 30 days of the data. And then finally in 2019, we lost the ability to go and look at that data at all. This legislation also banned the use of any sort of tenant blacklist, which I'm pretty sure was already against the law. Fines for violating this range anywhere from $500 to $1,000 per violation. And it's also worth noting that we now have lawful source of income legislation here in New York. And what that means is that we need to consider all lawful sources of income, be it from a traditional job, disability, retirement, Section 8, social services, child support, or any other form of lawful income. In addition, our credit and background check fees are now capped at $20, which is less than it costs to run a credit and background check in many instances. And if your costs somehow come in under $20, then you're only allowed to charge the amount that you paid. Now, let's hop in the jet and head on down the East Coast to Miami-Dade County in Florida. Housing providers in this area may not ask about or require the disclosure of a prospective or current eviction history on either the initial application or any subsequent renewal application. So essentially, you have to run all other aspects of your application process first and offer a preliminary approval before you can ask about or require the disclosure of a tenant's eviction history. This falls under ordinance number 22-47 if you're interested in looking up more information on this. Now, staying here on the East Coast, but heading back up north to Maryland, in Maryland, under bill number 49-20, a landlord cannot deny housing to an individual simply because they were arrested for a matter that did not lead to a conviction. They're also restricted from rejecting applicants convicted of nonviolent crimes such as trespassing, public urination, possession of marijuana, refusing to leave a public building, and misdemeanor theft, among some other minor crimes. Indecent exposure is also included on the list of covered offenses, but the bill does allow landlords to consider a tenant's sex offender registry status in addition to any sex offense arrests or convictions. This bill does not apply to housing occupied by the landlord. It also does not apply to homes rented by religious organizations or accessory dwelling units. Application fees are also restricted to $25 back in Maryland. All right, everybody back on the jet. We're headed to the Midwest. Specifically, we're headed to Cook County, Illinois, home of Chicago. The Just Housing Amendment requires housing providers to divide their screening process into two separate parts. The first part is essentially pre-qualifying the applicant. You start your application process by reviewing all aspects of the rental application, such as their eviction history, credit reports, employment, income, any bankruptcies, judgments, or liens. And only after you've gone through all that can you move on to the second part of the application process, assuming that this applicant passes through your pre-qualification process. Now, in step 2, you will be able to view the criminal history. A landlord may not consider any information related to a criminal conviction that are more than 3 years old and may not consider any information related to the applicant's arrest, charge, or citation record where there's no conviction, participation in a diversion or deferral of judgment program, record of an offense that has been sealed, expunged, or otherwise pardoned in accordance with applicable law, or a juvenile record or juvenile convictions. The restrictions on other information that cannot be considered are in line with the HUD recommendations and says that arrests alone without any sort of conviction are not valid for review. However, the time restriction of 3 years in this instance is pretty ridiculous in my opinion. All right, just a short hop on the jet this time up to Detroit, Michigan. This one is a local law in Detroit called the Fair Chance Ordinance. Landlords with 5 or more rental units are unable to ask their applicants about criminal records during the initial screening process. They must first determine that the applicant is otherwise qualified and offer them some sort of a conditional lease before they run the criminal background check. If you find a criminal background, you must allow the applicant to provide evidence of rehabilitation, and if they provide that evidence, it's up to the landlord to either accept or decline based on what they've been provided. If the landlord denies the applicant at that point, the applicant does have some recourse. They can actually file a complaint with the city's civil rights department, and if a landlord is found guilty of violating the ordinance, they'll actually be charged with a misdemeanor in this instance. Heading a little bit further west now to St. Paul, Minnesota, the Stable, Accessible, Fair, and Equitable, or Safe Housing St. Paul laws took effect in 2021. Landlords are barred from rejecting renters based on past criminal convictions, prior evictions, or poor credit reports. Landlords may reject renters who are registered sex offenders or who have been convicted of manufacturing or distributing drugs. Landlords can also reject applicants for convicted misdemeanors within the past 3 years or felonies within the past 10 years, unless those are traffic-related offenses. Renters cannot be rejected for poor credit scores. Landlords can, however, reject a tenant if the report shows a failure to pay rent or utilities. Landlords cannot reject renters for not passing a certain income threshold if they can show that they've successfully paid similar rent in the past. And finally, landlords cannot consider a renter's past evictions if they're older than 3 years old. These are some really, really stringent restrictions in St. Paul. Now, let's head back to the East Coast for our next one. We're heading to New Jersey, where we're looking at the FCHA, or Fair Chance in Housing Act. This act bars landlords from asking applicants about their criminal history on a rental application, in an interview, or in any other way before making an apartment offer. The purpose of the FCHA is to ensure that people with a past criminal history get a fair shot at accessing safe and affordable housing. Now, it is unlawful for a landlord to state in any of their advertisement that they are prohibiting applicants with criminal histories from applying for their housing. This law also prohibits a landlord from requiring any drug or alcohol tests prior to applying for the residence or being accepted. The only 2 exceptions to these laws are whether or not an applicant has ever been convicted of a drug-related crime for the production or manufacture of methamphetamine on the premises of a federally assisted housing facility, and 2, whether or not the applicant is subject to a lifetime registration requirement on the state's sex offender registry. A landlord in New Jersey may never, either before or after the issuance of an offer, ask about any of the following types of criminal records or rely upon these records in rejecting an applicant, no matter how this information is obtained. Arrests or charges that have not resulted in a criminal conviction, expunged convictions, convictions erased through an executive pardon, vacated and other legally nullified convictions, and juvenile adjudications of delinquency. Or records that have been sealed. Number 6 is records that have been sealed. So there you have it, a whirlwind trip around the country. Did we miss any of the oddball or unique screening laws in your area? Are you in one of the areas that we talked about here today trying to navigate these laws? Drop us a comment down below and let us know how it's going. Don't forget to like and subscribe. I'm Andrew Schultz with RentPrep.com, and we'll talk to you soon.